The offence of non-fatal strangulation is a relatively new offence which came in by virtue of the Domestic Abuse Act 2021. The Domestic Abuse Act 2021 introduced offences of non-fatal strangulation and non-fatal suffocation, as well as offences of racially and religiously aggravated non-fatal strangulation and suffocation. The offences came into force in June 2022 and are not retrospective, which means you can't be prosecuted for allegations which predate the law coming into force. The Domestic Abuse Act has changed the landscape for investigations and prosecutions in relation to domestic allegations. Frequently, we're seeing individuals being arrested initially in relation to just one incident, and then the investigation becoming far wider and broadening out and involving other types of domestic incidents. The law doesn't provide a definition of non-fatal strangulation, and the word should be given its ordinary meaning. The offence applies where the strangulation is non-fatal and doesn't result in the death of the victim. Again, for non-fatal suffocation, the law doesn't provide a definition of suffocation. The word should be given its ordinary meaning, which is to deprive somebody of air so that it affects their ability to breathe. At Olliers, we understand the complexity of domestic-related incidents. We understand that there are two sides to every story, and the side presented to the police in the initial complaint may not be what has actually happened. Allegations may date back over extended periods. They may involve allegations of sexual abuse, financial control, emotional abuse, and far more. Often, domestic-related allegations run in parallel with other matters between the parties, for example, proceedings before the family court, proceedings in relation to divorce and financial aspects of the separation. We often tend to find that complaints are made or additional complaints are made to the police at specific time periods during the family proceedings to coincide with important dates in those proceedings. We appreciate that matters are rarely as straightforward as may be presented to the police in the prosecution. We're often contacted by clients who may have been initially arrested and then released subject to pre-charge bail or released under investigation and have not yet been charged. This pre-charge stage of the case is absolutely crucial. It's the opportunity to be proactive, go on the front foot and engage proactively with the police and prosecution. We will always aim to make successful representations against charge and do all we can to minimise the chances of prosecution and the matter proceeding to court. We will look to engage with the police at the earliest stage of the investigation and adopt a process known as pre-charge engagement. We will seek to establish that there is not a realistic prospect of conviction or it is not in the public interest to prosecute, that being the test for prosecution. If you are facing an allegation of non-fatal strangulation or indeed any allegation of a domestic nature, then please contact our specialist team at Olliers and we will be able to explain how our proactive approach can assist you in relation to your case.